mention item number 6, my lord, may come up any day after 10 days, my lord.
On the request of Mr. J.I. Borbuya, learned counsel for the writ petitioner made with the consent of other side. Admission hearing of this matter stands adjourned for 2 weeks. List accordingly.
May please, your lordship, with regard to item number 7, lordship, there's some difficulty on our part today, your lordship. May I play the matter may come after puja vacation, your lordship. Item number 7, your lordship.
You are for whom?
I am for a respondent, your lordship.
Mr. G.
N. Gautam, your lordship.
G.N. Gautam, learned counsel appearing for the respondent in this case, seeks adjournment in this matter with a request to post this case again after the puja vacation. Since the prayer is not opposed by the petitioner's counsel, same stands allowed, list accordingly.
Lordship.
May to your lordship. I beg to pray for listing of a motion, preferably tomorrow, my lord. There is some difficulty which is.
What is the matter?
Lordship had directed a couple of days back on 20th that the registrar to take a call between A and B who would be the secretary of a society. Without deciding that matter, without notice, without hearing, the jurisdiction authority has written to the police that B is the secretary and he'll operate the things. This had led to a chaos. 29 is the AGM. At least they do the formalities as directed by the court, put to notice and then decide or not.
When is the meeting?
29th, my lord. Tomorrow. Next.
May I please, your lordship? My lord, I beg to mention item number 11, my lord, on behalf of the respondents. I have taken the consent of the petitioner's counsel. My lord, I pray, my lord, for an accommodation of 4 weeks. Let this matter come after puja vacation. We have some difficulty today, my lord. Item number 11,
You are appearing for whom?
my lord, the respondents.
I am appearing for the
My
petition.
lord, he is the petitioner, my lord. I am appearing for the revenue department, my lord.
Mr. R. Bapujari, learned standing counsel revenue department, Assam, appearing for the respondents, has expressed difficulty in conducting the hearing of this case today and therefore seeks posting of this matter for hearing again after the ensuing puja vacation. Since the prayer is not opposed by Mr. D.P. Bora, learned counsel for the writ petitioner, the same stands allowed. Let the matter be listed accordingly.
Obliged, my lord.
I am so obliged, my lord.
Well,
11 is connected with, no,
No, my lord, there is an I only, my lord.
all right.
I am obliged.
in respect of item, item number 1, 2, 3, and 4.
Hmm.
But although I have received the record and some instructions, my instructions are not complete. Lord. I pray for further 1 week time. Lord. I have informed the petitioner also. Lord.
You may only fix a date, Lord.
Date fixing will be after vacation. Otherwise for 2 weeks. What do you want?
After vacation, Lord.
Mr. D. Nath, this is item 1 to 4.
1, 2, 3, 4. Logic.
Mr. D. Nath Lanet, Senior Government Advocate, Assam, appearing for the respondents in all these cases, submits that although he has received some instruction, yet the same are not complete. Therefore, the learned Government Advocate Assam has prayed for posting these matters for admission hearing again after the ensuing puja vacation. Full stop. See, the prayer is not opposed by Mr. M. Kalita, K. Kalita, learned counsel for the writ petitioner. The same stands allowed. Register to list these cases accordingly. In the meantime, Mr. Nath to complete his instructions.
You may fix a date, Lord.
Huh?
You fix a date, Lord, after puja.
This the matter again on 16th of November.
Logic.
May please, your lordship.
These matters again on 16th of November.
May please, your lordship. Matter is pertaining to eviction, lordship.
Hmm.
Railway has given 15 days notice to the petitioners to evict for eviction, and today itself the 15 days time will be lapsed. Lordship.
Tomorrow.
Compulsory appointment for admission. They will listed next week.
Compassionate appointment.
Yes.
You have to go to the right bench. This is not bench 5 matter.
May I please, your lordship? Should beg to mention for listing for pending writ petition for motion, your lordship. Matter relates to holding of annual general meeting, your lordship. Lordship, notice was not issued in this matter, your lordship, so
Friday.
obliged.
May it please, your lordship.
Why don't you have it on Monday? What is the urgency?
Lordship,
Monday or Tuesday? That is
lordship, as per last order, it was supposed to come this.
3rd October. Put the date. 3rd October.
Obliged.
May it please, your lordship. Lordship, I beg to mention item number 13 of today's list.
Mhm.
Lordship, in this case, we are led by Dr. Ashok Saraf Lordship, he has some personal difficulties today, Lordship. Lordship, may I pray that the matter may be taken up after puja vacation, Lordship.
14-15 also analogous, Lordship.
So 12 to 15.
12 we are
12
not
we
appearing.
Aware, Lordship, 13-15 are analogous, I'm sure. But 12, since it is tagged maybe, but I'm not aware, Lordship. regarding.
But it is listed together.
I am appearing in item number 12, my lord. I think my matter is different from the other, my lord. Therefore, it may be segregated.
All right, you take down learned counsel for the writ petitioner appearing 13 to 15, huh? Appearing in these cases has sought adjournment of hearing of these cases with a request to post the matters again after the puja vacation. Since the prayer is made with the consent of the opposite party, the same stands allowed. Let these matters be listed accordingly. 13 to 15.
May I pray for a date, Lordship, if possible?
16th of November. Post again on 16th of November.
Much obliged.
May I please the lordship, I beg to mention one item for listing, lordship. It's for substitution of petitioner number 3. Kindly the matter may be listed for orders, lordship.
Next week, next week.
May I please your lordship, I beg to mention, one petitioner died, so we filed substitution petition. Kindly fix next week.
You filed an IA.
Lordship,
It has been numbered.
lordship,
What is the number of the IA?
27/27/2023.
Okay, we'll have it on next Wednesday.
Lordship,
Yes, put the date. 4th of October, put the date.
lordship,
Yes.
obliged.
Please. I'm paying for listing one motion matter, lordship, eviction, lordship. The railway authority issue notice for eviction, lordship, without their consent, lordship. The land is under the GMD, lordship.
When do you want it?
Tomorrow.
This matter kindly time being, Passover for time being, my lord. Mr. KK Mount is coming, my lord, first. Just is on the bar.
Then we'll take it as last item after other matters are over. Yes.
Supplementary list for admission item 17.
In this case, lordship, we have been directed to notice was issued, lordship, but we have not yet received any instructions, lord.
Then appears for the writ petitioner, Mr. H. Sharma, learned additional senior government advocate Assam, appearing for the official respondent, submits that instructions as called for are still awaited. And therefore, this writ petition be posted again in the second week of November 2023. Ms. G. Hazarika, learned standing counsel revenue department, is also present and makes a similar request. In view of the above, let this writ petition be listed in the second week of November 2023. Yes,
18 is also same, lord.
along with item 18.
Much of it.
For orders item 7.
Seven has been mentioned. 7 has been mentioned.
For hearing item 8. Item 9.
So what has happened in item 8? Who is appearing? It is
Lordship, matter may be taken up sometime. Planning, conducting counsel is in court. 1.
In item 9, we are for.
item 8. We are in item 8. Yes, what has happened in item 8, Mr. Goswami? Any development?
They propose my lord, artificial link, whether that can be fitted or not. For that, my lord, directed to take a opinion from the legal board.
Study কৰিব দিলো, নকৰিলে। It is difficult to verify the estimate. Has to be demonstrate কৰিব লাগিব, তেতিয়াহে verify কৰিব পাৰিব।
That product is to be placed before the board actually.
So what is the meaning of this?
Well, without,
They have given a quotation only, my lord, so that was placed before the board. The board without physically verifying the product, my lord, cannot ascertain. my lord.
some demonstration has to be there, well,
So
otherwise,
you want time for that?
Basically, my lord, they have in touch with a company, my lord. If that company, it's a demo, my lord.
So I'm asking what order is to be passed today?
Some adjournment, my lord, will coordinate with the petitioner and that company, my lord, so that
well, we
Uh,
have two queries. Number one, that whether it will be fit to the victim or not. That they said that demonstration has to be there, otherwise without on papers only they cannot say. And secondly, from the as regard any scheme, etc. of the government, they said there is no scheme.
No, scheme or no scheme doesn't
Got
matter. This is now.
Only the feasibility of putting that or whether it will work on the victim or not.
All right, Mr. D. Nath Lanet, Senior Government Advocate, Assam, has appeared and produced a copy of the communication dated 14/9/2023, issued by the Superintendent of Guwahati Medical College Hospital. A perusal of the communication goes to show that the authorities are seeking a demonstration of the myoelectric, MYO electric prosthesis from the humanoid HUMA and OI, the Humanoid Prosthetics and Orthotics Center, so as to verify and record a satisfaction as to whether the product would serve its purpose if fitted in the patient Master Pragyan Vaishya. Full stop. For the aforesaid purpose, Mr. Nath submits that a competent medical board of experts will have to examine the same. And therefore, this matter be posted again after 6 weeks for completing the process. Full stop. In view of the submission made by Mr. Nath, this matter stands adjourned for 6 weeks. Copy of the communication dated 14/9/2023 be retained in the record of this case, and upar likhibo Mr. P.N. Goswami, learned additional AG, Assam, has appeared. Tar pisot dibo Mr. Nath so and so, because the communication is to him, I have recorded it.
make it more workable, my lord. The chief engineer PWD, my lord, will coordinate with this humanoid
Chief engineer,
PHC, man.
super-
Humanoid prosthetics for.
The Chief Engineer, Public Works Department, Assam, is directed to coordinate with the
This agency, my lord, humanoid.
Humanoid Prosthetics and Orthotics Center for the purpose of arranging a demonstration of the product.
chief engineer, PWD person.
PHC, man.
Huh?
Chief Engineer
Chief Engineer PHE, not PWD, PHE.
And they will coordinate with the
Yes.
medical board.
Will coordinate with so and so and the medical board through the Superintendent Guwahati Medical College Hospital for the purpose of arranging a demonstration of the product at the earliest. A report be placed on the next date fixed.
Lodge.
Yes.
My lord, this matter is very voluminous, my lord,
Matter is?
very voluminous, my lord. And other thing is that, my lord, they have suppressed the fact that already their title suit seeking right title already dismissed, my lord. I have brought on record.
So what is this matter about?
They are challenging the mutation revenue board judgment, my lord. It's a revenue board judgment dated 19/5/2011, my lord. And in the meantime, they have also filed one title suit, my lord. That title suit has been dismissed.
What is the number of the title suit?
I have annexed in my affidavit, your lordship will find running page 544.
Why don't you give the title suit number?
Title suit 396/2005. 396 of 2005.
In which court?
Court of Civil Judge, Senior Division Number 2, Guwahati. And thereafter, my lord, because of that judgment, my lord, on earlier occasion, your lordship will see your lordship order. On 3 occasions, they remain absent. And their case was dismissed for default, my lord. Subsequently, they revoked it, my lord. And second thing is, my lord, this judgment, my lord, there is no such infirmity, my lord. Only thing is they have made it voluminous by including several other materials which
Right,
are.
you take the non-appears for the writ petitioner when the matter was called up before this court today. Mr. H. Sharma, learned additional senior government advocate Assam is appearing for the state. Mr. B. Borua, learned counsel for the
Respondent 8, 10, 12, 13, and 14.
respondent numbers 8, 10, 12, 13, and 14 are present. Mr. Borua has pointed out that there is no infirmity in the judgment and order passed by the Learned Revenue Board, Assam, assailed in this writ petition. Moreover, it is also the submission of Mr. Borua that the petitioners had filed title suit number 396/2005 before the Court of Learned Civil Judge, bracket Senior Division Number 2, bracket close, Guwahati. But the said suit for declaration of title in respect of the land in question had been dismissed. Yes, full stop. As such, submits Mr. Borua, there is no live issue in this writ petition, full stop. Next paragraph. This writ petition was instituted in the year 2012. Stop. I find from the record that the petitioner's counsel was absent on 21/10/2019, as well as was absent even on some previous occasions, full stop. Having regard to the peculiar facts and circumstances of the case, as well as the submission made by learned counsel for the private respondents, this court is of the opinion that due to the long lapse of time and the judgment and decree passed by the learned civil court, the petitioners have lost interest in pursuing this matter any further. Full stop. In view of the above, this writ petition stands dismissed for non-prosecution.
Obligement.
Miss case also disposed of. There is a miss case. Miss case is also disposed of. Yes.
May I present, Lordship?
Item 10. They have a standing council of the veterinary and animal husbandry lordship.
Let us see what is the matter. What is the matter?
Yes, Lordship, matter relating to the compensation of death, Lordship. Petitioner's son died due to. Lordship, may I read the paragraph 2 of my petition, Lordship? Petitioner is the widow late Ajibur Rahman and mother of the deceased Soburuddin, who died on 3/2/2012 at about 12 p.m. due to fell down of concrete stone wall of the veterinary hospital of Pup Jaruni Sub-Center Doboka in the district of Nagaon. At the time of the tragic incident, the victim was about 20 years. The son of the petitioner was a driver and his monthly income was ₹10,000, Lordship. In this, after the occurrence.
Have you submitted any claim?
Yes, Lordship.
Where
Page
is it?
23, Lordship. Page 23, Annexure 6, Lordship. I have
Page
submitted
23.
representation before the authority, Lordship.
There is no page 23 in your writ petition.
Annexure 6, Lordship.
Petitioner is the mother of the deceased.
Yes, Lordship.
So who is for the veterinary? You are not appearing. Then we'll ask the director to consider his claim and pass a reasoned order.
Miss M. Kapoor. Kotoki, M. Kotoki.
All right, your name, please.
AK Azad, Lordship.
Heard Mr. A.K. Azad, learned counsel appearing for the writ petitioner. Also heard Mr. J. Handik, learned additional senior government advocate Assam, who is present on behalf of the official respondents. None is appeared for the Department of Animal Husbandry and Veterinary, although the name of the learned standing counsel.
Name not been reflected in that.
अच्छा although ना लगे कुछ तो ये तो करने लगे none is appeared for this so and so कुछ तो the writ petitioner herein is the mother of Abdul Subur, who died on 03/02/2012, apparently having suffered shock and hemorrhage due to injuries received by him on account of fall, FALL, fall of a concrete wall of the veterinary hospital of Pug Jaroni Subcenter, Doboka, Nagaon, Assam, upon the body of the deceased, upon the deceased, full stop. The deceased was aged about 20 years and was working as a professional driver at the time of his death. Full stop. On what is the date of the representation?
Date of the representation, Lordship.
After the death of Abdul Subur, UD case number 02/2012 was registered in the Murajhar PS police station. First of, however, after conducting investigation in the matter, the police had submitted based on the FIR dated 3/2/2012, Murajhar PS UD case number 02/2012 was registered and the matter was taken up for investigation. However, upon conclusion of investigation, final report was submitted on 2/2/2014. The final report clearly mentions that the victim had died due to fall of wall upon him. First up. The petitioner's husband had submitted a representation dated
There is.
Not there. We will file a press release.
submitted an undated representation before the director of veterinary department, Nagaon, Assam, enclosing a copy of the postmortem report, driving license, school certificate, and other relevant documents of the deceased person, seeking compensation for an amount of rupees 15 lakhs for the death of his son. Full stop. Mr. So-and-so, learned counsel for the petitioner, submits that the death of the petitioner's son had occurred purely on account of negligence on the part of the officials of veterinary department, and therefore they are liable to pay compensation due to the untimely death of petitioner's son, who was an earning member of the family. Full stop. Mr. Hendrick submits that the learned standing counsel veterinary department who is handling the brief is not available today in the court, full stop. Be that as it may, this matter pertains to the year 2014 and the incident occurred in the month of February 2012. Full stop. As such, this is a very old pending matter, full stop. I also find from the materials on record that the representation annexed as Annexure 6 does not contain any date, full stop. Moreover, better particulars justify the award of compensation is also not discernible from the representation bracket Annexure 6, full stop. In view of the above, adjudication of the claim of the petitioner in this writ petition based on the materials available on record would not be possible. Full stop. However, since it is the admitted position of fact that the son of the petitioner had died due to the collapse of a concrete wall upon him, which belonged to the veterinary department, leading to loss of life of her son, the claim of the petitioner for payment of compensation cannot be completely brushed aside by this court, since the same would have an element of infringement of Article 21 of the Constitution of India, first up. Situated thus and having regard to the peculiar facts and circumstances of the case, as well as the long lapse of time since the last representation was submitted, I dispose of this writ petition by granting 4 weeks' time to the petitioner to file a detailed representation before the Secretary to the Government of Assam in charge of Veterinary and Animal Husbandry Department, ventilating her grievance in the matter. Full stop. If such representation is submitted by the petitioner within the time specified by this court, then the same be considered on merits, and after proper inquiry, the representation of the petitioner be disposed of with a speaking order within a further period of 6 months. Full stop. With the above observation, this writ petition stands closed.
My lord, with regard to item number 9, my lord, your lordship has passed that it was infractions. My lord, it is actually not infractions. The other side, my lord, actually I was in another court, my lord, so I could not come in time.
No, I have dismissed it.
This is for default.
Yes,
Actually,
but anyways, there is a title suit.
that
What has happened?
title suit, my lord, different parties they have filed, but this is the regarding mutation, my lord. But some observations were made by the Assam Board of Revenue. These are very problemsome. my
No,
lord.
then you get the other side. Then only I'll be able to change the order. It will अपने type ना कोई word. You get the other side.
Yes.
But I will dispose it of in any case.
Yes,
By saying that you go to the
actually,
civil
I
court.
am ready, my lord.
Go to the civil court, these observations will not have any bearing. That's the order I'll pass. These are not matters that requires adjudication. These are civil disputes, civil court. Yes. You please call the other side and I'll change the order, but it will be disposed of. Yes.
Item 12.
May it please your lordship. This matter pertains to my lord assessment bill, my lord, and order passed by the APDCL, my lord. My lord, background of the case is that, my lord, on 24th of May 2018, the team of APDCL officials, my lord, from the Terms and Condition Department has inspected the premises of the petitioner, my lord, and they have prepared a report whereby it stated that the petitioner has connected excess load to the mains, my lord. On that basis, the team has forwarded the same to the chief executive officer. Then it has been forwarded to the assessing officer, my lord. The assessing officer has passed the provisional order, my lord. In that regard, my lord, before filing objection against the provisional assessment order, my lord, the petitioner has asked for some documents from the Assistant General Manager, my lord, AERC. Later, my lord, the document has not been provided, but hearing has been held, my lord. And ultimately, the petitioner came before this High Court, and the Honorable Court has directed to furnish the documents. Before furnishing that document, again pass another order as the assessment order, my lord. Then, my lord, the petitioner again came before this court, and Honorable Court again directed the authority to furnish documents. And later, my lord, the authority has passed the final assessment order, my lord.
What is the date of final assessment order?
My lord, the assessment order found at page, my lord.
Final assessment order, what is the date? I'm not asking the page number.
That is, my lord, 26th of September 2018, my lord.
Hmm. What has been held in the final assessment order?
My lord.
What is being held in this final assessment order?
As per the assessment order, my lord, a bill has been prepared amounting to rupees 55,75,045 rupees for payment, my lord.
So is this assessment order not appealable?
Appealable, but my lord, I have SL whole inspection procedure, my lord. As the authority has not followed the regulation, the supply code, my lord.
That's right, you take these grounds in the appeal.
Yes.
Otherwise, everybody can come to the Reed Court adding 1 or 2 more grounds.
Yes, my lord, I have bona fide belief that as I have excelling the law, my lord, question of law, that's why, my lord. If your lordship grants me some relief, my lord, I may approach the appellate authority.
What is the relief you want?
Relief, my lord, one that is 30 days time, my lord, already over, my lord. And another, my lord, 50% have to deposit, my lord. I have already deposited in pursuance of interim order 25%, my lord. It may be considered as, my lord, security, my lord.
The
In terms of 50, my
statute
lord.
provides for 50%, my lords.
Yes, my lord.
We'll change it.
Well, there are orders, well, there are judgments passed but rendered by the Honorable Division Court, bench, my lords, of our Honorable High Court. When it says, my lord, there
You
is
don't want the matter to go to appellate authority.
matter should go, my lord, but the deposit of
No,
50%.
the deposit will be 25%. I'm disposing of this matter.
The statute for a moment, my lords.
I am passing that order. Let this statute be there. There is already, this order is already there in the Reed petition.
My lords.
Otherwise,
Even on the point of maintainability, my lords, this writ petition is not maintainable, my lords, because the Honorable Division Bench has rendered a judgment whereby it is stated, my lords, in the presence of a statutory appeal or remedy under 127, a writ petition is not maintainable, my lords. That is the point I'm urging, my lords.
all right.
May I just place those judgments, my lords' consideration?
You give a list, I'll record it, but I'm sending it to the statutory authority, giving him 30 days time. And the statutory deposit 25% that he has deposited, that will be treated as interim deposit. That is the order I'll pass. These are not necessary. The court is automatically, this writ petition was earlier, the interim order has been passed. It
Interim
will not
order has been-
vacate it now. It will be unequitable to do that.
My lords, the statute, the provision, my lords, in the statute.
We'll direct that it will be waived.
Well, on an observation to the effect that it may not be treated as a precedent, my lords.
All right.
That observation, because my lord, there are other matters pending and it pertains to revenues of the
Then
APDC.
we'll hear it today. It need not go to,
The remedy is
then
there.
you argue, let us hear it today. If you don't want your own authority to hear it, then we'll not hear it, then
No,
they'll.
my submission only being on the point of maintainability, my lord.
But supposing the writ petition is allowed, your only option will be Supreme Court, which is a very difficult option.
That, my lords, subject to what my lordship holds, my lord. There are judgments, my
No,
lord.
you make a submission that you will not insist on further deposit. Otherwise, we'll hear it and pass an order.
That is my lordship discretion, my lord. My lordship may direct that. But there is, may I just place that judgment for a moment, my lords? My lords, may I kindly have the judgment rendered by the Honorable Coordinate Bench, my lord, since Shiv Eloise. And that is Shiv Alloy Steel, my lords, in WPC 3427 of 2021.
Yes, yes.
My lords. Para 7 of that judgment, my lords.
Hmm.
Issues by frame, my lords. Point 7C of the judgment, my lords. Whether considering the factual matrix, this writ petition is maintainable.
Hmm.
Now, my lords, para 25 onwards, there is a discussion on that issue, my lords.
Para 25.
25 onwards, madam, on that issue itself. Identical situation, my lords, unauthorized usage of electricity. Para 26, my lords, I'm reading. In the present case in hand, the petitioner challenged the final order passed under subsection 3 of section 126 of the Act of 2003, along with the order of consequential reliefs. The issue decided herein above shows that the final order passed under subsection 3 of section 126 also include that one against the unauthorized use of electricity, where there is an allegation of theft of electricity under one so and so. Subsection 1 of section 126 of the Act authorizes the assessing officer to initially raise the provisional assessment to the best of his judgment. The electricity charges payable to the consumer after the inspection. Subsection 3 of 126 of the Act allows the affected consumer to be heard, and thereafter the assessing officer is required to pass a final order of assessment. In the present writ petition, as herein above taken note, the petitioner disputed the provisional assessment and the final assessment or order on the ground that there was no cogent region so and so. Accordingly, issues raised in this writ petition are factual in nature, coupled with technicalities of the metering system and so and so. Section 127 of the Act allows any person aggrieved by the final order made under section 126 of the Act to prefer an appeal before the appellate authority prescribes under the said section. Now, let's para 28. The appellate forum under section 127 of the Act of 2023 is equipped to decide both factual issues as well as technical issues. Moreover, the issues involved are related to revenues of the respondent APDCL. Accordingly, in my considered view, this is not a fit case to invoke Article 226 of the Constitution of India, considering the statutory alternate remedy in the form of an appeal, and as such, the writ petition is not maintainable, and the issue number C, that is whether considering the factual matrix, this writ petition is maintainable, is decided against the petitioner, my lords. Assailing this very order, my lords, judgment, my lords, the petitioner had approached the Honorable Division Bench, my lords. I'll just pass that. Para 9 of that order, my lords, of the DB. Of para 9, my lords. After
Yes.
considering the rival submissions of the parties, we are of the opinion that presently the remedy available to the writ petition, appellant is an appeal under section 127 of the Electricity Act, where he will have liberty to place all his points, including whether due process under section 126 had been adopted or not, and whether the quantum of assessment is in order. As a statutory remedy of appeal is provided to the writ petitioner appellant, we are in agreement with the opinion of the learned single judge that the writ petition appellant should approach the appellate authority first for redressal of his grievance. On this issue, my lord, the writ petition itself is not maintainable, my lord. That is my submission.
All right. His assessment has been made under section 126.
126(3), my lords.
Of the Electricity Act 2003.
3, my lords.
And where is the interim order? What is the date of the interim order passed in this case?
Interim order is of, my lords, perhaps of 12th October 2018, my lords.
Have you filed any application for modification of this order?
That has not been filed, my lords. There is an affidavit where we've taken, my lords, a stand of as regards the availability of a statutory remedy.
Okay, and which is the provision which says 50% has to be
My lords,
deposited?
section 127, subsection 2, my lords. There's also a limitation of 30 days, my lords, but that has to be limitation of 30 days, my lord. That, my lords, perhaps not, should not be insisted upon, my lords.
Thirty days is provided by which provision?
Section
My lord,
127, subsection 1, my
123 itself.
127, subsection 1.
That subsection 3 says.
All right.
Assessment within
Well,
30
may I also
days.
point out one thing, my lords? There was an earlier order passed in an earlier writ petition filed by this petitioner itself, my lords. The relevant portion of that order, my lords, is at page 46 of the writ petition. my lord. There is a direction
Yes.
by this honorable court, my lords, for the petitioner to appear before the assessment officer, appellate private authority, my lords, on 20th September 2018, my lords. Last paragraph, para 8, my lords.
This writ petition was by petitioner.
Petitioner, very same petitioner, my lords.
This was earlier round.
Earlier,
Earlier, my lord.
earlier on.
That
he
is
was-
over now.
That is over, my lord. There was a direction for him to appear on a certain date, and the date was fixed for the appellate authority to hear the matter, my lords. Now, on that very day, my lords, the petitioner did not appear before the authority, my lords.
My lord, due to some
No,
health
that's all right.
problem, my
We'll
lord.
not comment on that.
Right.
Let this
Just
statutory.
My duty to point out, my lords. While passing the impugned assessment order, my lords, he was not present on the date fixed by this honorable court.
Hmm. Take down heard Mr. M. Saikia, learned counsel appearing for the writ petitioner in item 12, huh? This is item 12. I have also heard Mr. B. Chaudhary, learned standing counsel APDCL, appearing for the official respondents. Full stop. By filing this writ petition, the final assessment order dated
26 September.
26/9/2018. Asked by the assessing officer. Confirming the interim, the provisional order of assessment dated 16/8/2018, thus imposing. Thus raising an electricity bill of rupees
55 lakhs, my lord.
55 lakhs. Give the complete figure.
55 lakhs 75,045 rupees.
55 lakhs 75,045
Yes, your lordship.
has been put under challenge in the present writ petition. Internally on the ground that the impugned final order dated 26/9/2018 has been issued in a most arbitrary manner and without giving proper opportunity to the petitioner to present its case.
Yes, sir.
Full stop. Taking note of the grievance expressed in this writ petition, the learned single judge of this court had passed order dated 12/10/2018, issuing notice upon the respondents, full stop. By way of an interim measure, it was also provided that subject to deposit of 25% of the assessed electricity dues as per the final assessment order, electricity supply to the premises of the writ petitioner shall not be disconnected. Full stop. By virtue of the order dated 12/10/2018, the petitioner is continued to enjoy electricity supply upon deposit of 25% of the amount raised in the final assessment bill. Full stop. It further appears, next page, it further appears from the record that at this stage of no, appears from the record that the learned standing counsel for the APDCL had questioned the maintainability of the writ petition at the very threshold by urging that the order assailed in the writ petition was appealable under section 127 of the Electricity Act, 2003. Full stop. This said stand of the APDCL authorities has subsequently been brought on record by filing affidavit. Full stop. Today, when the matter is called up, Mr. B. Chaudhary has strenuously argued on the question of maintainability of the writ petition with a request to the court to direct the petitioner to avail appellate remedy. Full stop. The learned standing counsel APDCL has further submitted that the period of limitation of 30 days for preferring the appeal as prescribed under section 127 bracket 1 numerical 1 bracket close of the Act of 2023 may run from the date of this order if the court directs the petitioner to avail the appellate remedy and the respondents would not have any objection on that behalf. Full stop. Responding to the above, Mr. Saikia, learned counsel for the petitioner, has submitted that an appellate remedy is indeed available to the petitioner, and his client is also ready and willing to avail such remedy. Full stop. However, in order to avoid any hardship and prejudice to the petitioner, 30 days time be granted for preferring the appeal. It is also the submission of Mr. Saikia that the
May I point out one thing, my lord? Coordinate bench has already in other case, my lord, has granted 25%, my lord, that may.
all right. Mr. Saikia has further submitted that in similar situation, coordinate bench of this court had passed orders waiving the statutory deposit of 50% as prescribed by section 126(3) of the Act of 2023 by confining the amount to 25% of the total bill and full stop. Therefore, Mr. Saikia has prayed for a similar order in this case as well. In support of his above argument, the learned counsel for the petitioner has placed reliance on the order dated so and so. On the order dated. (14-3) 2023 passed by this court in WPC number 955/2019, third bracket, Messrs. Blueberry Industry versus this APDCL and others. Full stop. Next better. Mr. Chaudhary, on the other hand, has relied upon another decision of this court rendered in the case of Shiv Alloy Steel versus APDCL and others, reported in 2021 bracket close 4 GLR 558 to submit that allowing the petitioner to pursue the appellate remedy by depositing only 25% of the amount would create a bad precedent, which will be against the mandate of the statute, and therefore the same may not be permitted by this court. Full stop. I have considered the submissions made at the bar and have also gone through the materials available on record. At the outset, it deserves mention herein that the instant writ petition is evidently and admittedly directed against the final order of assessment dated
26 September 2000.
26/9/2018, which order is appealable under section 127 of the Act of 2023. First up, from a careful reading of the grounds for challenging the order of assessment, it is apparent that there are several factual issues involved in the matter, factual disputes involved in the matter, which would require thorough scrutiny by a competent forum, which is the appellate authority. And therefore, I find force in the submission of Mr. B. Chaudhary that the writ petition be closed on the ground of availability of alternative appellate remedy to the writ petitioner. Full stop. Coming to the question of statutory deposit and the plea of limitation as prescribed by section 127 bracket. Now, coming to the question of application of period of limitation and as well as the statutory deposit as prescribed by sections 127 bracket numerical 1 and numerical 3 bracket respectively. It has already been noted that the learned departmental counsel has submitted that his clients would have no objection if 30 days time from the date of this order is granted to the petitioner to prefer appeal. As such, the said aspect of the matter need not detain this court. First of all, coming to the final issue in this proceeding relevant at this stage, which is pertaining to the statutory deposit, this court finds that by the interim order dated 12/10/2018, the interest of the petitioner to enjoy continuous electricity supply was protected upon deposit of 25% of the assessed electricity dues within courts. First step. The order dated 12/10/2018 has no, you're right. The respondents have not sought modification of the order dated 12/10/2018, as a result of which the said order continued to hold field for past nearly 5 years. First of under the circumstances, even if there is a statutory requirement under section 127(3) to deposit 50%, having regard to the facts and peculiar facts and circumstances of the case, I am not inclined to expose the petitioner to a deposit of higher amount of money merely because the matter is being referred back to the appellate authority. First of all, therefore, it is clarified that no further deposit over and above the 25% deposit already made by the petitioner shall be insisted upon for the purpose of admission of the appeal to be preferred by the petitioner under section 127 of the Act of 2023. The petitioner is granted, however, the same shall not be treated. However, the aforesaid relief is being granted to the petitioner in the peculiar facts and circumstances of the case, and the same shall not be treated as a precedent for future purpose. With the above observation, this writ petition stands disposed of by granting 30 days time to the petitioner with effect from today to prefer the appeal under section 127 of the Act of 2023.
What was the order, Maloj, my learned friend was relying upon, where there is a deposit of 25%, Maloj? There are 11 of that order, Maloj. Maloj, may I just read that?
You do it in the next case.
Maloj, may I just read that? Perhaps it's relevant, Maloj. Because the court had observed, Maloj, that the APDCL would not insist upon any further deposit at the time of admission of the appeal. my lords. It is, however, at the time of its admission, petitioner shall pray for further exemption, in which case the said prayer would be considered by the appellate authority.
Shall not 25%. In other words, the FPDCL authorities shall not insist on any additional amount over and above the 25% deposit made by the petitioner at the time of admission of the appeal. The above order is, however, only an interim relief which will be subject to final order that will be passed by the appellate authority.
I will excuse me, regarding item 783, you also already passed the order. My only prayer is that you also will speak on 21st of November. May I pray to prepone the date, my lord?
When?
Any date, first week of November.
First week of November is a holiday.
First week, actually.
Huh?
Then a little
Second week
earlier,
of November is the first week after vacation. How can it be preponed?
then let it be in October, my lord. Any date is October.
October not possible.
Otherwise,
Whatever
my
goes
lord,
now
eventually,
is,
the problem is that our land has been acquired by the government.
it has to be in November. Second week is the earliest. You can't have it earlier than that. The holiday schedule has been changed.
But any day in the month of October is not possible.
Mr. Biswas, I have already declined that prayer. Why are you repeating it again and again? October is not possible.
Then, my lord, after the reopening, my lord,
It has already been given. It's in the second week of November. That's when it is, courts are reopening.
can it possible on that day,
Huh?
November, not 21st November? my lord.
Who said 21st? Second week of November. No order of 21st. 21st, is there any order to post it on 21st? Second week of November. First week is a holiday.
Yes.
Well, with regard to
Electricity Act, 2003.
item number 9, my lord,
Hmm.
and it will be here.
So you go to the civil court. That's the order I'll pass. Nothing beyond that.
Actually, my lord, they are the purchaser, subsequent purchaser. my lord.
Hmm.
I am the original title holder and original owner of the land, my lord. They purchase from some other person, my lord.
So this is a civil dispute. It cannot be decided on the basis of revenue board order.
Then there are some certain observations, my lord. That is the problem here.
Observation, the civil court will not be influenced by the observation. That will clear. Where is the order of?
They have already filed certain civil suit against us also, my lord. But this observation, actually, they are taking guard of this observation, my lord, that
Will clarify that these observations will have no bearing in the civil court.
In fact, I have annexed the title suit judgment, my lord.
Who has filed the title suit?
They filed, my lord. That is the loss.
Your client has filed.
earlier that is different suit, my lord.
Petitioners filed.
A series of suits are there with regard to this land, my lord. My lord, their original vendor, he grabs the land, my lord, without his name. Thereafter, he filed a mutation application.
Who
my
is
lord.
in possession of the land? Who is in possession?
Actually, at present, my lord, I am, and in some portion there also, my lord, because there are 3.
So, Mr.
respondents, my
Kalita, see, you understand it. These are not matters the writ court can decide. It has to go to civil court. It
Your
will go
lordship,
to civil.
your lordship can dispose of this case, my lord, but only one observation should be necessary,
Yes,
my
what
lord,
is it?
that this observation given in the Assam, by the Assam Board of Revenue, that will not affect the civil.
All right, where is the order of the Assam board?
That is
Which
at
observations you are,
page 310, my lord,
page 310?
10. Assam Board of Revenue, my lord, just like a civil court, my lord, decided this case. That is the problem.
Which are the observations you are agreed with? The paragraph numbers?
Yes, my lord, that is. At page 323, my lord.
Yes. Paragraph number?
Paragraph number, top, my lord, last portion of the para, my lord. So it is beyond reasonable doubt that the disputed land was the self-acquired property of late Tajmul Hussain. Then secondly, B.A. Cohn or respondent should have been a patterer. My lord, in this case, what happened, my lord, a question arises, my lord. They allege that the relinquishment deed, whether the relinquishment deed can transfer the land or not. They question that point, my lord, here. Assam
So
Board
what
of
happened,
Revenue-
your mutation in respect of your client's name has been cancelled.
Yes.
Then you
Yes.
preferred an appeal that has been dismissed.
No,
Appeal, we
there
have
are-
preferred.
Huh?
We have preferred appeal.
You preferred appeal?
Yes. Our
The-
owner is we have inherited land from our forefather. Yes,
Just a minute. So your mutation was cancelled.
yes.
You
Cheetah
preferred
petition.
an appeal and that has been allowed.
Yes, my lord.
Then you went to this, they went to the civil court.
Yes, they filed another, they were.
But that was before the order of the
Before
revenue
of the
board.
order.
Yes.
And that was subsequently in 2014, that was decreed against them, holding that relinquishment does not give any right title. Now against that, they have again preferred appeal in High Court. My lord. First appeal
So
is.
we'll say that the
Yes.
mutation order will abide by
Yes.
any decree to be passed by the civil court pertaining to the land.
Yes.
That
That is-
it is a fact that there is a first appeal pending. But without framing a issue, my lord, the learned trial court, my lord, decided that the relinquishment deed is not.
That is another matter. We can't go into that in this case.
Only, my lord, with this judgment, my lord, only these observations which are against the civil court, that is the civil courts, my
Mr.
lord.
Kalita, you please listen to the order. After that, if you have any suggestions to make, we'll change it.
Yes.
All right, you take that. Heard Mr. P.K. Kalita, Learned Senior Counsel, assisted by Mr. D. Talukdar, Learned Counsel appearing for the writ petitioner. Also heard Mr. B.J. Talukdar, Learned Senior Counsel, assisted by Mr. P.K. Mehdi, Learned Counsel appearing for the respondent numbers 1, 2. Respondent numbers 1 to 4. In this case, Mr. B. Borua, Learned Counsel has appeared on behalf of respondent numbers
8, 10, 12, 13 and 14.
8, 10, 12, 13 and 14.
Yes.
The remaining respondents have remained unrepresented before the court today, full stop. In this writ petition, the judgment and order dated 19/5/2011 passed by the learned Assam Board of Revenue, Guwahati, in case numbers 310, you will find the case number, page 310. 1, 2, 3, 4, 4 case numbers are there. Have been assailed primarily on the ground that the learned revenue board, while deciding the appeals in favor of the private respondents, have made observations and have recorded findings touching upon the question of right, title and interest of the parties, more particularly the writ petitioners herein, thereby causing serious prejudice to their interest. Full stop. Mr. Kalita, Learned Senior Counsel for the writ petitioners, has argued that the Board of Revenue does not have any jurisdiction or authority under the law to make any observations on the question of title of the parties over the disputed land, nor can it record any finding as regards the question of legitimate inheritance of immovable parties, immovable properties by the legal heirs of the rights holders. Full stop. Mr. Kalita therefore submits that his clients are primarily aggrieved by the observations made in the judgment and order dated 19/5/2011 in different places, which would have a adverse bearing on the question of title of the petitioner if the matter is ultimately taken up before the civil court. Full stop. Mr. B. Borua, Learned Counsel for the private respondents, on the other hand, submits that the questions arising in this proceeding are pure questions of title and ownership of the land, which can only be decided by the civil court. Therefore, he would have no objection if the writ petition is closed by clarifying that the observation of the learned Board of Revenue would not have any bearing on the question of claims and counterclaims of the parties if a civil court involving the land is instituted by either side. Full stop. If that be so, this court is of the opinion that adjudication of the other issues raised in the writ petition would not be relevant. It is pertinent to mention herein that being aggrieved by the order dated how many orders were challenged? Number of orders were challenged, is it?
Actually, my lord, original.
Aggrieved by the orders
Yes.
passed by the revenue, by the settlement officer,
Yes.
cancelling mutation of the private respondents over the disputed land. Appeals under section 147/151 of the Assam Land and Revenue Regulation was preferred. Order dated 10/12/2008, passed by the settlement officer. In Miss case number 19/08-09. There are a number of appeals, 4 appeals. Why?
All are separately filed, my lord.
Originally, my lord,
Combinedly taken.
Separate appeals were filed by the aggrieved parties under
Issued.
section 147/151, numbered and registered as those 4 appeals, to give the number, which were disposed of by the common judgment and order dated 19/5/2011, allowing the appeals. Stop. After a careful stop. The operative part of the judgment and order dated 19/5/2011 is reproduced herein below for ready reference. Page 333, you will get it. Full stop. After going through the readings in the writ petition and on hearing the submissions made by learned counsel for both the sides, this court is left with no manner of doubt that the key issues arising by and between the contesting parties would have to be resolved in the before the competent court of jurisdiction by filing appropriate civil suit. Full stop. Therefore, by clarifying that the observations made in the judgment and order dated 19/5/2011 would not have any bearing if either party to the proceeding refers a civil suit involving questions of title and ownership in respect of the land in question. This writ petition stands disposed of by providing that if and when such civil suit is instituted in accordance with law, the learned civil court will decide the matters without being influenced by any observation made in the judgment and order dated 19/5/2011. Parties to bear their own cost. Send back the LCR.
Obligation.
Is it the second round, my lord? This is the second round.
Second round, third
Earlier,
round.
there was already High Court order, sir. Yeah.
Item 16.
May I please, your lordship?
The last item. Yes.
My lord, the petitioners before your lordships are the selected beneficiaries, my lord, for the purpose of the Pradhan Mantri Awas Yojana houses, my lord. And they were selected during the 2011, my lord, 2011, my lord. Now, my lord, what happens, my lord? Only technical point is there, my lord, for which, my lord, perhaps the government has filed affidavit, my lord, saying that their names have been deleted. Why deleted, my lord? These petitioners are not known to the Zoiramkusi Gaon Panchayat. Zoiramkusi Gaon Panchayat says that we do not know these people. So Gornogar GP, my lord, they have written letter that no, these people are known to us. They are the villagers, residents of Gornogar Gaon Panchayat, but they are not earlier benefited. So this letter now, my lord, Zoleshwar Block, video Zoleshwar Block has sent a letter after verification of those the petitioners, my lord, and for necessary action, my lord. And when, my lord,
You please take your seat. Let me just go through it. Where is the representation 21/10/2021?
My lord, page 91, my lord.
Page 91.
91. 91 to 95.
So where is the report of the BDO, Jaleshwar?
BDO, my lord, page 86, my lord. Page 88, my lord. GP secretary has written.
So what is the stand of the department?
My lord, respondent number 5 has filed affidavit, my lord. In paragraph 4, we have stated after the deletion of, there is a window period of 15 days, my lord, for claiming any objection against that rejection, my lord, as per guideline, existing guideline, my lord. But that was not done. They have made.
Yeah, poor people forget your.
My lord, they have made representation.
Why was the name deleted in the first place?
It is as per Gram Sabha meeting, my lord. Some resolution has been taken on Gram Sabha. According to that, they could not proceed, my lord.
Which Gram Sabha?
That is Lakhipur Develop. Joyram Kusi, my lord. That is paragraph 4. It is mentioned, my lord, in our affidavit. Page 97 of.
No, you see, forget Gram Sabha. Your officials are instrumentalities of the state.
My lord.
Are they not supposed to implement central government schemes in a fair and non-discriminatory manner?
That is true. My
Suddenly
lord,
you exclude some people.
According to paragraph 9, that guideline, provision of guideline is mentioned, my lord. So they are bound by that, my lord.
Which guideline?
It is. Framework of implementation under Pradhan Mantri Awas Yojana, my lord. Relevant portions. I have procured.
Paragraph 9 of your affidavit.
Yes, my lord. Page 98. At the filing of writ affidavit, my lord, I could not procure that relevant portion is mentioned here.
So the scheme is still in vogue.
Yes, my lord. That copy I have.
No, the GSY scheme is still alive.
Alignment.
Huh?
Alive.
My lord, that instruction I have to take, my lord, because on the basis of some census, it is phase wise that allocation was.
No, what is the reason for deletion of petitioner's name?
First of all is that is technicality, my lord, that 15 days objection period. They have
Oh, that
taken
I'm
as-
not accepting. Forget your technicalities.
But the Gaon Panchayat that is actually difficult to name. It actually, the petitioners are residents of that Gaon Panchayat. They have stated that these petitioners are unknown to this particular Gaon Panchayat.
No, but there are reports that they are members of the Gaon Panchayat. The secretary says that.
Video that the petitioner is referring to is of a different village. You see at the beginning of the para 4, so the petitioners may be resident of Joyram Kusi Gram Panchayat. This is the Panchayat that is actually deleted in name under Lokhipur Development Block. This video is not from Lokhipur Development Block, but regular voters of Gaurnagar Gram Panchayat under Joleswar Development Block. The videos
So
of this
petitioners are residents of which development block?
will be
Petitioners
under the
are
Lokhipur
they are
Development.
residents of Gaurnagar Gaon Panchayat, my lord, under Joleshwar block. But during my lord census, the people's my lord, they were included under Joyram Kusi Gaon Panchayat during census. Therefore, Joyram Kusi my lord says that these people are not known to us because they are the residents of Gaurnagar Gaon Panchayat. Now, Gaurnagar Gaon Panchayat has clarified it that they are known to us and they are not benefited earlier. They have clarified it. And Gaurnagar under Joleshwar Development Block and Joyram Kusi under Lokhipur Development Block. Therefore, Development Block Joleshwar has written letter to Lokhipur Block.
No, just a minute. The names of the petitioners are included in the census for which block?
They are, my lord, for Joyram Kusi Gaon Panchayat under Lokhipur Block.
And they are residents of?
They are original residents of Gaurnagar Gaon Panchayat under Joleshwar Block.
Residents of which Gaon Panchayat?
Gaurnagar Gaon Panchayat.
What is the spelling?
Gaurnagar Gaurnagar Gaon Panchayat.
Under which block? Jaleshwar.
Joleshwar Development Block. Because of this gap, my lord, they have been victimized, my lord.
As per the affidavit, in para 4, it is the other way, It says that the petitioner residents of Joyram Kusi Gram Panchayat, which is under Lokhipur Development Block, but regular voters of Gaurnagar Gram Panchayat under Joleshwar Development.
So they are residents of which Gaon Panchayat? You tell-
Joyram Kusi Gram Panchayat.
Give them as Joyram Kuchi Gaon Panchayat then.
The Joyram Kusi Gram Panchayat have stated that they are unknown.
Unknown because they are the residents of Gaurnagar Gaon Panchayat. Only during the census they are included under Joyram Kusi. Therefore, Joyram Kusi says they are not known to us. And Gaurnagar GP has clarified it that they are our residents of our GP. Earlier not they are benefited.
And Gaurnagar is under Jaleshwar Development Block.
Joleshwar Development Block. Very neighbor, my lord. 2 blocks, Joleshwar, Lokhipur, neighboring development blocks.
So let the project director look into the matter
Mine.
and take a decision. Till that time, no further, no benefit will be. What is the interim relief that can be granted to them?
Actually, they had a statutory relief, They were supposed to challenge this deletion of the name within 15 days, Post
Whether
verification.
any
But then
allocation
they
is
have come
left
up-
out, my lord, that we could not say right now, my lord.
These court therefore wanted to know that resolution. My lord, they could not produce that resolution also. And we do not know behind back
Which resolution? Which resolution?
by who is we are said to be deleted.
It is stated in the affidavit, a resolution been passed on that ground floor to remove 16.
But where is the resolution?
A copy later on sent to me, my lord.
And there should be publicity, my lord. There should be drumbeat so that we also can participate in the proceeding. It has been done behind our back, my lord, we do not know.
It's okay.
So what, we can't issue a direction to allot. The direction can be only to verify your claim.
That can be, my lord, and on phase wise if possible, because government is giving by inviting the people. This is the, my lord, scheme known as housing for all, my lord.
This is which district?
Gwalpara district, my lord.
Huh?
Gwalpara district.
In fact, my lord, after court direction, my lord, one indication has been sent to us stating inter alia that it is not possible to re-include the names of the by the authority. However, there is every possibility of inclusion of the names of the petitioner during the next socio-economics and caste census or any other survey to be conducted for the purpose by the government, and thus they may be entitled for future beneficiaries of PMGY, my lord. That instruction I have given after the court order, my lord, whether they can be adjusted in, they can be reallocated the houses now, my lord. It's a written instruction, my lord.
You show it to him.
So in that manner, keeping into account this, my lord, their grievances can be mitigated for the next session.
My lord, only the time bound program. If the scheme, my lord, goes, then what will happen to us, my lord?
What to do? This list is for a particular. This list is for the beneficiaries coming under Joiram Kuchi Gaon Panchayat. Under Lakhimpur Development Block, my lord. But you have not been, you are found to be not residents of
Joiram Kuchi.
Joiram Kuchi.
We are originally residents of Gaurnagar Gaon Panchayat under Zoleshwar block, but during socio-economic census, these people are included in Joiram Kuchi Gaon Panchayat, and therefore, my lord, our names deleted because we are not known to them. They have said. Therefore, they wrote a letter, and Gaurnagar Gaon Panchayat accordingly, my lord, said these people are known to us and they are not earlier benefited. Otherwise,
So what is the solution?
Solution, my lord. So far, instruction concern, my lord. I know.
All right, you take down, heard Mr. F.N.O. Mullah, counsel appearing for the writ petitioners, also heard Ms. M. Bormon, learned government advocate Assam appearing for the respondent numbers
2, 4, and 5.
2, 4, and 5. Mr. N.K. Devnath, learned standing counsel, Panchayat and Rural Development. You are appearing, Mr. Mehdi? CGC? No CGC. Mr. N.K. Devnath, learned standing counsel, Panchayat and Rural Development Department, Assam, is present on behalf of respondent numbers 3, 6, 7, 8, and 9. None has appeared for the respondent number 1. Full stop. The writ petitioners herein, numbering 40 in total, are the ordinary residents of Gaurnagar Gaon Panchayat coming under the Jaleshwar Development Block. First stop. According to the petitioners, they had not received any benefit earlier under the government-sponsored housing scheme, and therefore were entitled for allotment of dwelling houses under Pradhan Mantri Awas Yojana -Gramin, then bracket close, PMAY-G, bracket close, which had commenced with effect from 1st April 2016. First up, when the petitioners were expecting that they will receive the benefits under the scheme, they were surprised to find that their names were deleted from the list of beneficiaries forwarded by the secretary to the Joyram Kuchi Gao Panchayat coming under the Lakhimpur Development Block. Lakhipur Development Block coming under the Gwalpara district. Full stop. Aggrieved thereby, the instant writ petition has been filed. Full stop. On receipt of notice, the respondents have appeared. The respondent number 5 has also filed an affidavit. The respondent number 5, that is the project director. Project director DRDA, Gwalpara has also filed counter affidavit contesting the claim of the petitioners. Full stop. From the materials available on record, it appears that the stand of the departmental authorities is to the effect that the names of the petitioners is not included in the, what is this called? Not included in the list of beneficiaries under the Joyram Kuchi Gao Panchayat prepared during the socio-economic and caste census -2011 carried out across the country. Full stop. That is the result. That is the reason why the secretary of the Gao Panchayat did not include the names of the 40 petitioners in the list of beneficiaries. Full stop. However, Mr. Molla submits that during the last socio-economic and caste census, the name of all the petitioners were included in the list of beneficiaries pertaining to the adjoining their names are included in Joyram Kuchi.
Joyram Kuchi included.
Then last line, what is written? No, under the Gaurnagar Gao Panchayat coming within the Joleshwar Development Block and Joleshwar Development Block based on the list prepared by the socio-economic and caste census -2011 conducted across the country. That is the reason their names were not included in the list of beneficiaries. Stop. Responding to the above, Mr. Molla submits that the names of his clients are included in the list of beneficiaries in the adjoining block, that is in the adjoining GP, that is Jairam Kuchi Gao Panchayat coming under the Lakhipur block, although they are ordinary residents of Gaurnagar Gao Panchayat. Full stop. This discrepancy occurred during preparation of the list of beneficiaries during the socio-economic and caste census -2011 for reasons not known to the petitioners. However, the petitioners cannot be deprived of the benefits under the PMAY-G scheme merely on such technical grounds when they had no fault in inclusion of their names in the adjoining Gao Panchayat. Full stop. Mr. Molla has further submitted that his clients are genuine beneficiaries who are entitled to receive dwelling houses under the scheme, and therefore, if an order is not passed by this court protecting their interest, then the same would result into serious prejudice to the rights of the petitioners. Full stop. Ms. Burman, learned government advocate Assam, and Mr. Devnath, Learned Standing Council PNRD Assam, have submitted in tandem that after the list of beneficiaries was published, the aggrieved persons had 15 days time to raise an objection under the
PMC guideline,
under the
PMAYZ guideline.
conditions of the scheme, but the petitioners have remained silent in the matter. As such, their claims cannot be considered at this distant point of time. However, as and when future benefits are announced for the residents of Gornagar GP, the petitioner's case will be considered. Full stop. The aforesaid stand of the learned government advocate Assam is found to be wholly unacceptable. Full stop. The fact of the matter remains that inclusion of name of beneficiaries in the list is a matter for the authorities to decide based on realistic inputs. Full stop. If the petitioners are residents of Gornagar GP, which fact is apparent from the communication dated 21/11/2020 issued by the Block Development Officer, Jaleshwar Development Block, Katari Hara, bracket annexure 4, then it is not understood as to why their names were included in the list of beneficiaries for the Jairam Kuchi GP coming under Lakhipur block. Full stop. Be that as it may, since the petitioners are otherwise eligible for benefits under the PMAY-scheme G scheme, they cannot be denied of such benefit merely on such technical ground. Full stop. Although Ms. Borman has submitted that having failed to raise any objection within 15 days, the petitioner's claim stood extinguished on technical grounds, I find that it is the stand of the departmental authorities which is rather technical and not it is the stand of the departmental authorities that the petitioners cannot be granted that to the effect that the petitioners cannot be granted benefit under the scheme since their names are recorded in the list of beneficiaries pertaining to the adjoining Jairam Kuchi GP is rather technical. Full stop. It is not in dispute that the PMAY-G scheme is still active and the benefits under the scheme is yet to be exhausted. In view of the above and considering the peculiar facts and circumstances of the case, this writ petition is disposed of with a direction upon the respondent numbers 3, 4 and 5 to verify the claim of the petitioner, and if found to be genuine, necessary benefits under the PMAY-G scheme be extended to them. Necessary benefits under the PMAY-G scheme be extended to them, if necessary, by taking cognizance of the inclusion of their names in the list of beneficiaries in the adjoining block. Full stop. So as to enable the official respondents to carry out the aforesaid exercise, petitioners to furnish certified copy of this order before the respondent numbers 3, 4 and 5 to do the needful. With the above observation, this writ petition stands disposed of. Yes,
Sometimes they
the exercise as directed by this order be carried out and completed as expeditiously as possible, but not later than 6 months from the date of receipt of a certified copy of this order.
deeply obliged.
Writ petition stands disposed of. Yes, whose matter, Mr. Mohanta? So affidavit has been filed. There is no need to file any rejoinder. No need to file any rejoinder.
Because this is a matter of records only. They have not been able to show anything else.
So that's all right. We don't want to file it. So I'll come in 15 minutes, then we'll take it up. But now we'll finish it off. You are John.
It has to be, otherwise by interim order, they are. Met please, your lordship. The facts are like this. For the distribution of food grains to the fair price shops, the whole exercise is done through the GPSs, Gaon Panchayat level cooperative societies and the wholesale cooperative societies. These two organizations are there. They are the authorities who mediate. The supply is made by the government through the FCI. Rice, basically the rice.
The supply of food grains.
Food grains, basically rice. Only rice here. Now, so FCI, through FCI, it comes to the GPSS level cooperative society, Gaon Panchayat level, or the wholesale cooperative societies, those are there. They distribute to the fair price shops. In my case, I have been appointed as a transporter. As a transporter to, firstly, my first duty is to bring it from the FCI go down to the particular Gaon Panchayat level cooperative society. And then thereafter, when the Gaon Panchayat level cooperative society receives it, they make allotments to their respective agents, fair price. Records are with them. They make allotment and they give me that list. Accordingly, I have to distribute it from there to those agents.
So that is the tier 2.
Tier 2. So tier 1, I have to take it whenever allotment is made. That allotment is received by the Gaon Panchayat. I mean the cooperative society in the FCI. Then they call me, they come take it. I am to take it with what formalities, and then they accompany me, and I take it to their go down, and it is stored there. And thereafter, they take time to make allotments. They gave me allotment sheets later on. The time limit is there 15 days, but it is not strictly adhered to. Sometimes 3-4 days. This way, that way is always there. And then when I'm given that allotment sheet, I have to take it and distribute it to those agents. Now, what happened here? In the first try, I have taken it. Grains were allotted. I am to transport it. I have transported and given it to the Rohmuria, Gaon Panchayat level, Thomas Committee level. They have taken it. They have stored it there. But it is tier 2. They were supposed to give me the allotments. Those were not coming forth. Those were not coming forth. So I was waiting for my inquiry to her telephone. They said, wait, we are doing it. After few days, it was found. After 15 days gone, on 17th day, the authorities discovered that there was manipulation. Those gunny bags, which contain the rice, those have been exchanged with the FCI. When they give it, it is in the jute gunny bag. They found that it is in the plastic gunny bag. Because
no, that exchange happened at which stage?
In the go down of the GPSs.
GPSs.
At the later stage. Before this was allotted to me, once allotment will be made, and I will be informed that you take this allotment sheet and go and distribute it to those FC, the fair price shops. That has never coming. In the meanwhile, they on their own did it, made the exchanges, manipulations. That was detected because few, I'm told, my instruction is that fair price shops, they keep on inquiring when will be allotment made that, and they detected there, when they were shown that these are, decks are different this time. That's how the matter went to the authority. They made an inquiry and then found that yes, there was manipulation at that level. And therefore, after the inquiry, they have detected the whole facts and filed an FIR against the office bearers of the society, Samabaya Samiti. That FIR, on the basis of that FIR, actions have been taken, they have been arrested, they're detained. Now, the deputy commissioner, because there is a clause that I am also bound to distribute it to the second tier, to the fair price shops. Simply on the basis of this, whether that was given to me or not, whether there was any procedure to be followed or not, they gave me a notice. I showed causes, all these points, told them that this is the situation. I showed the documents, allotments, since earlier they used to give it to me, on the basis of which I used to distribute. So I said that I had no hand there. I am simply a distributor. I have taken it and given to them. It was in their custody, lying in their godown. What they did, I am not supposed to know. Had it been given to me, and I have taken it for.
All right, which is the order you are challenging, Mr. Mohta?
Therefore, now the order Lordship will find, page 66, the order which has been passed, misinterpreting the clause of the agreement. They have just posted it on me. Lordship will kindly come to 66 page. I will just read it slowly, Mala. Peruse the inquiry reports submitted by C. So-and-so, Inspector Dibrugarh, relating to inquiry conducted and seizure executed for 200 quintals of rice at MS Rohmoria, Samabaya Samiti Limited on 17/6/2023. Further, peruse the FIR submitted at Rohmoria Police Station, Dibrugarh. It transpires from the case records that the chairman and secretary of the GPSS are involved in malpractices with substitution and diversion of highly subsidized TPDS rice under NFSA 2013 in league NFSA transport contractor. Now, this has come by his own. Also peruse the NIT number so-and-so dated 18/2/18 and the tender agreement dated 9/2/2018 made between the district administration and Messrs. Nobo Gogoi, my farmland, along with so-called notice served to the NFSA transport contractor, namely Nobo Gogoi, who was entrusted for transporting NFSA 2013 rice to Messrs. Rohmoria Samabaya Samiti Limited in both tier 1 and tier 2 stages. The so-called reply dated 29/5/23 submitted by Sri Nobo Kumar Gogoi of Messrs. Nobo Gogoi is also perused and found that the NFSA transport contractor had miserably failed to substantiate the charges about their involvement in substitution and diversion of highly subsidized NFSA 2013 rice in league with the secretary and chairman of Messrs. Rohmoria Samabaya Samiti Limited, whereas the transport contractor has submitted documents regarding delivery of NFSA 13 rice.
First of all, where is the show cause notice?
Show cause notice is
To be given to the petitioner.
This is at page 59. Page 59, Annex 7. 59. Annex 7, page 59. Whereas it is dated, my lord, 21st May 2023. Whereas the inquiry conducted by a team of so-and-so officers, Dibrugarh, Rohmoria Samabaya Samiti, is detected that the secretary and board of directors of the GPSS are involved in malpractices and diversion of highly subsidized TPS rice. As per the provisions of serial number 6 of tender agreement dated so-and-so, executed by your firm, the transport contractor shall deliver the allotted food grains transported by them to the nominee GPSS and WCC in tier 1 and to the FP shops, fair price shops dealers in tier 2, properly without any loss, damage, storage, shortage, and or its quality and quantity. On the other hand, as per the provisions of
serial number 10 of the tender agreement, the transporter shall be responsible for any loss, damage, leakage, theft, replacement with inferior quality of the transported food grains and shall have to compensate for any such irregularities besides liable to face prosecution as per provisions of law. Whereas the Samai Samiti has not distributed TPDS rice to the FPS dealers for onward distribution, kindly note this, to the beneficiary within the government stipulated time frame, that is 15/5 of May 23 quota and June 23 quota till 17/5/2023, the date of inquiry. The whole allotted quantity is believed to be diverted into open market in league with the office bearers of Messrs. Rohburiya Samabay Samiti to garner undue illegal profit. Whereas Messrs. Rohburiya Samabay Samiti possessed 200 quintals of rice, 400 packets in plastic packets, which is not issued by FCI under TPDS. It is clear evidence of substitution of TPDS rice contravening the provisions of clause 11(3) of the Targeted Public Distribution System Control Order 2015. Being the transporter of the GPSs, you are liable to supply the goods grains to the GPSs as well as in the doorstep of the EPFs dealers under the GPSs. You are found to have lifted the transported the allotted 872.60 quintals of rice for May 23 in the month of March 23 and 874 quintals of rice for the month of June 23, lifted and transported in the month of April 23 from FCI Saulkhwa FSD. The non-distribution of the said allotted quantity to the concerned EPS dealers in time indicates that you in league with the GPSs substituted and diverted the TPDS price under NFSA 2013 for illegal personal gain. This is the basic allegation. Non-distribution of the said allotted quantity to the concerned EPS. The above facts are clear exhibits of contravention of the terms and conditions of the tender agreement dated 9/2/18 and the terms and conditions of NIT to number so-and-so dated 18/2/2016. Therefore, you are asked to show cause as to why NFSA transfer contract shall not be terminated. This is the notice. Now, basic allegation is that non-distribution of the said allotted quantity to the concerned EPS dealers in time indicates that you in league with GPSs substituted and diverted it. So apparently those were in the custody of the GPS society. That I am in league, there is any role to be played by me, they will have to prove it, they will have to substantiate it. There is nothing. Apparently there was no allotment made. It is the case of their own that I have diverted, I have taken it and delivered it to their godown. It was there in their the society was in possession. Now, I have replied it, my lord. Next page, 60. I have categorically said there from paragraph 2 onwards, I have stated how the whole process I have stated, how I take delivery, how I carry it, how I deposit it in presence of their people in tier 1, and then how to make allotment, how I take the.
Yes, what is your stand, Mr. Talukdar?
Lordship may kindly come to the speaking order, my lord. It has been detailed from paragraph 2-3, my lord, of the speaking order. Page 66, my lord. During the personal hearing undertaken on 22/6/23, Sri Nabakumar Gogoi and so failed to substantiate the charges
No, he will not substitute the charge. You want to
Lordship will
substitute.
kindly go down below, my lord. Then skipping that part. The delivery of transported food grains duly signed by the recipient of FP shop and counter signature of the secretary and so and so, as per mandate of point number 7 of the transport agreement. While the transporter was questioned about the effecting tier 1 delivery in June 23 quota without completion of tier 2. So without completion of tier 2, he knew that he had to give it to the
Yes,
delivery.
no,
to the,
Mr. Talukdar, let us come to the brass tacks. Show me an order which was given to the transporter to deliver, which he did not.
No, there is no, the agreement itself is a composite. He has to tier 1, he has to leave the goods from FCA godown and deliver it to the GPSS godown. Then within before 15th of
So
each
he will
month,
decide where the goods should go.
the GPSS will give them the
Where is
location.
the instruction given by GPS?
GPS did not give, so he has never raised any issue, that issue before the authority.
All right, another 5 minutes. I'm allowing this
And
finish. There's
it
nothing
is
else.
not that he knew, because he delivered it to one person. It is there in the
Mr.
speaking. order.
Talukdar, I am asking you a simple question. I have read the documents. You see, the allegation is against the office bearer of Romaria.
Yes, they have to fix because-
They might have.
Yes,
Now, it's very clear. He says that I was given the contract for transport for both tier 1 and tier 2.
Yeah.
So tier 1 I have carried out. Tier
Carried
2 I was not given instruction.
not given
therefore-
instruction. If it is not given instruction by 15th of every month, then he could have raised that issue. He did not.
If he did not raise that issue, that is a violation of contract.
My lord, because of that,
Which clause says that?
even after that, he lifted the first tier 1 for the next month.
But these are all irrelevant. The order says malpractices, he did not deliver in tier 2. There is a clause which says he will have to compensate for any loss, damage, etc., theft, etc. So therefore, the contract is terminated.
So
This is
because,
completely unacceptable.
because
There is no finding that there was
there
theft
is
or.
there is a stipulated date for delivering to the doorstep.
No.
He had crossed that date, but in spite of that, he never raised any claim.
No, so that
No
doesn't
way.
lead to termination of contract.
And that apart, he had delivered to one fair price shop. So he knew that things are lying there.
So, Mr. Talukdar, I'm asking a straight and simple question. Does the transporter on his own get the authority to take out?
No, he could have raised that issue before the authority also. He could have
All right.
done it.
Yes. How much time you need?
There's
There's nothing in the writ petition. We'll allow it. This is wrong order.
But my submission will be recorded, my lord, that one part he had delivered. Knowingly that other parts are still left to be delivered.
Correct.
He did not raise that issue
Right.
before anybody,
Right.
not before. the
Nobody
GPSS.
raised the issue. Even this deputy commissioner did not raise the issue.
No, deputy commissioner is not aware of
No,
that.
there is no automatic. Where is the show me the automatic scheme in the contract agreement? Which
No,
is the contract agreement?
is at page 20. Firstly,
Page 20.
your lordship will see it's a composite contract, whereas the transporter so and so shall perform transportation work of food grains in 2 tiers. Tier 1 from FSD Dibrugarh to so and so to go down of GPSS under Tengaka development blocks so and so. Tier 2 from GPSS go down to doorsteps of FP shops located within the so and so. So he has to do both this work. And then lordship may come to 6. Next page. The transport contractor shall deliver the allotted food grains transported by them to the nominee GPSS and to the fair price shops dealer tier 2 properly without any loss, damage, shortage, etc. of its quantity and quality. Transporters shall obtain a receipt from the LOT GPSS
and fair price shops after successful delivery of the transported food grains duly signed by the recipient and countersigned by the executive officer, secretary of the concerned GPSS. Then 9, Lordship may come to 9. The transporters shall adhere to the lifting program of food grains provided to them by the authority FCI and shall be bound to complete the delivery of allotted food grains to nominee in time within the validity period. The time is, my lord, 15th of every month. The transporter shall be responsible for any loss, damage, leakage, theft, replacement with inferior quality of the transported food grains and shall have to compensate for any such irregularities. Now,
This is a contract agreement entered in the year 2018.
18.
Valid till? We are in 2023 now.
It is not there. In so many words, it is not there.
This is continuing.
Huh?
This is continuing.
Continuing, there is no dispute. Probably then 11, your lordship will see any dispute will be subject to jurisdiction of legal forum district.
So High Court cannot entertain.
High Court, I am not saying that, but if it is a
Lordship has
disputed question of facts, my lord, then.
no disputed question of facts. Lordship will get
Because there is a finding that
Yeah.
he is in league with the.
where from that substantiated? Is it my duty to substantiate I am in league? Kindly see, my lord, here it is specific that the allottee 9 and 6 and 7, lordship will see the clause, page 21. Allotment must be made in the second tier by to the office of dealers. The transporter contractors have delivered the allotted food grains. It must be allotted, transported by them to the nominee GPSS and WCS and to the office of.
All right, heard Mr. K.K. Mohanty, learned senior counsel listed by so-and-so appearing for the writ petitioner. Also heard Mr. Vijay Talukdar, learned senior counsel listed by Mr. P.K. Medhi, learned government advocate Assam appearing for the for all the respondents, full stop. The instant writ petition is directed against the order dated. What is the date of the order? No date. Huh? No date.
It has not June 23 days.
Undated order passed by the Deputy Commissioner Dibrugarh, that is. That is the respondent number.
Respondent number.
Herein. The inter alia cancelling the contract agreement dated 9/2/2018 entered into by the respondent number 3 as a first party with the writ petitioner herein for transport of
Food grains.
Food grains. Full stop. The facts of the case in a nutshell is that in the year 2018, that is in the year 2018, the respondent number 3 had entered into a contract with the petitioner for supply of for transportation of food grains from the FCI Gordon to the wholesale cooperative societies, that is WCCS, as well as the Gaon Panchayat Samavai Samitis, bracket GPSS, and thereafter to the fair price shop dealers under the Dibrugarh municipality area and the Naharkatia town committee area, full stop. The terms and conditions of the contract agreement envisaged a two-tier TIER transportation mechanism, full stop. Under TIR-1, TIER-1, the contractor is required to transport the food grains from the FCI godown at Dibrugarh to the godowns of WCCS public GPSS full stop under Tier 2 Roman capital 2. The food grains were required to be transported from the GPSS godowns to the doorstep of fair price shops located within the GPSS area. By following the similar mechanism, the transporter, that is the petitioner, was also required to transport food grains from the WCCS to the fair price shops located within the Dibrugarh municipal urban areas and the Naharkatia town committees, full stop. Accordingly, the writ petitioner continued to execute the contract as per the terms and conditions laid down therein, full stop. According to the submission made at the bar, although the original contract agreement dated 9/2/2018 was valid up to 31/3/2018, the writ petitioner continues to execute orders of transportation under the same terms and conditions for the subsequent years, which was valid for the current year, that is 2023, full stop. Full stop. According to the writ petitioner, it had transported the food grains allocated to it for the year 2023 from the FCI godown to the respective WCCS stroke GPSS, thus completing the Tier 1 level of supply, full stop. However, due to non-availability of any further order from the concerned WCCS stroke GPSS for the Tier 2 supply, the petitioner could not commence the said phase, although as per the terms and conditions of the contract, it was required to transport the goods to the fair price shop dealers within 15 days. Stop, full stop. In the meantime, an Ejahar was lodged before the officer in charge Romaria, ROHMARIA police station, Dibrugarh, district Dibrugarh on 31/5/2023 by the Inspector of Food, Civil Supplies and Consumer Affairs, Dibrugarh, alleging serious malpractices on the part of the office bearers of the Romaria SS Limited, leading to diversion of highly subsidized TPDS rice under NFSA, 2013. Full stop. Based on the aforesaid Ejahar, Romaria PS case number 11/2023 was registered under section 120(b)(406)/409/420 IPC, read with section 7 of the EC Act, and the matter was taken up for investigation. First of, the president and secretary of the Romaria SS Limited were also arrested by the police in connection with the aforesaid case. Full stop. The matter is currently under investigation. Full stop. In the meantime, on 21/5/2023, the respondent number 3 had issued a show cause notice upon the petitioner, asking it to show cause as to why the contract agreement should not be terminated, and the value of the diverted quantity of rice should not be realized from the petitioner. Full stop. On receipt of the show cause notice dated 21/5/2023, the writ petitioner had submitted its show cause reply on 27/5/2023, explaining his position while categorically denying its involvement in any unfair practice as alleged against the president and chairman of the Romaria GPSS. First up, notwithstanding the same, by the impugned order issued in the month of June 2023, dated DSC, issued in the month of June 2023, bearing number DSC.02/2023/195. The contract agreement was terminated, the security deposit of rupees 10 lakhs placed by the writ petitioner before the respondent number 3 was forfeited, and an order was issued to recover the price of diverted rice jointly from the chairman and secretary of MS Romaria Samabhay Samiti Limited, as well as the writ petitioner. First up, aggrieved thereby, the instant writ petition has been filed. Stop. By referring to the materials available on record, Mr. Mahanta, learned senior counsel appearing for the writ petitioner, has vociferously argued that the writ petitioner would not have transported the food grains to the fair price shops under the tier 2 level of transportation unless specific instructions oblique memos were issued to it by the respective GPSS oblique WCSS, indicating the name of the FPS dealer and the quantity that was required to be transported. Full stop. In the present case, no such memo was received by the petitioner, as a result of which the transportation could not be carried out in the tier 2 level. Full stop. The learned senior counsel for the writ petitioner has further argued that the alleged malpractices have been detected while the rice quantities were stored in the godown of Romaria SS Limited and in the custody of the aforesaid Samiti, and the writ petitioner had nothing to do with the same. Full stop. According to Mr. Mahanta, the allegation of malpractice is clearly directed against the president and secretary of the Samabhay Samiti Limited and not against the writ petitioner. However, on a complete misconstruction of clause 10 of the tender agreement, the respondents have not only terminated, the respondent number 3 has not only terminated the contract agreement, but has fastened huge liability on the petitioner by observing that the writ petitioner has failed to failed to substantiate the charge. According to Mr. Mahanta, Mr. Mahanta therefore submits that the impugned order bracket annexure 10 is vitiated by complete non-application of mine, and the same deserves to be set aside by this court. Full stop. Responding to the arguments advanced by the petitioner's counsel, Mr. B.J. Talukdar, and as senior counsel and government advocate Assam, appearing for the respondents, has contended that as for the contract agreement, the writ petitioner also had the responsibility to ensure that the transportation of goods were completed not only at the tier 1 level, but also at the tier 2 level. First of, even assuming that the petitioner did not receive memos from the GPSS for carrying out the tier 2 level of supply within the stipulated time period, even then, it was incumbent upon the transporter, that is the read petitioner herein, to raise the issue and register a complaint before the respondent, before the officials, which it had failed to do. So in the instant case, therefore, the complicity of the petitioner in diversion of food grains cannot be ruled out. Full stop. Mr. Talukdar has further argued that the petitioner did complete the tier 2 level of transportation from
Tier 2 level was not completed.
Acha.
Then tier 1 for the next month was lifted.
No, that's not relevant. Plus, what did you? No, this further argued that full stop. On such ground, the learned government advocate Assam has argued that there is no merit in this writ petition and the same is liable to be dismissed. Full stop. I have considered the submissions made at the bar and have also gone through the materials available on record. Full stop. From a careful reading of the impugned order, Beckett Annexure 10, I find that the respondent number 3 has observed that the writ petitioner was in league, LEAGUE, with the secretary and chairman of MS Romaria Samavai Samiti Limited for diversion of rice quota. Full stop. However, the impugned order dated so and so does not record any finding of fact based on cogent materials available on record so as to arrive at such a conclusion. Rather, it appears that the conclusion drawn by the respondent number 3 as regards alleged complicity of the petitioner in diversion of rice is a mere assumption based on circumstances which were not disclosed, which are not clearly disclosed in the impugned order. Full stop. Since the respondent number 3 has relied upon clauses 6 and 10 of the tender agreement, of the contract agreement, so as to terminate the contract, it would be apposite to reproduce the relevant clauses of the contract agreement. Full stop. As such, clause numbers 6 to 10 of the contract agreement is reproduced herein below for ready reference. Page 21 and 22 you will get. Full stop. A plain reading of the aforementioned clauses of the contract agreement, more particularly clause 8, clearly goes to show that the responsibility to ensure timely loading and unloading of food grains by the transporter contractor is on the district authority. Full stop. The aforesaid clause would also, the aforesaid clause in the tender agreement is clearly indicative. The aforesaid clause in the contract agreement, when read in the context of other clauses, would clearly indicate that the responsibility of the contractor, bracket transporter, was only to adhere to the lifting program of food grain provided to them by the authority /FCI, and the contractor was bound to complete delivery of allotted food grain to the nominees within time. Full stop. The lifting of food grains and the delivery of the same were to be carried out under the supervision of the district authorities. Moreover, the contractor cannot lift food grains, be it tier 1 or tier 2 level, unless instructions for lifting of food grains and the delivery address is given to it. Full stop. In the present case, materials on record indicate that diversion of food grains by the mechanism as projected by the learned government advocate Assam was detected while the food grains were stored in the godown of MS Romaria SS Limited. Full stop. The contractor oblique transporter does not have any access to the goods stored in the godown of the SS Limited. Full stop. During the period of storage of the goods in the godown, the responsibility for storage of such good would clearly lie on the concerned WCCS oblique GPSS and on the authorities stroke inspectors in charge of in charge inspector under whose supervisions the WCCS and GPSS are located. Full stop. Clause 10 of the agreement no doubt makes the transporter responsible for any loss, damage, leakage, theft, replacement with inferior quality of transported food grains. But the said clause would be operational only if there are materials to suggest that the loss, damage, leakage, theft and oblique replacement had taken place while the food grains were in transit and in the custody of the transporters, not otherwise. Full stop. In other words, the transporter cannot be made responsible for any loss or damage under clause 10 while the food grains were in the custody of the GPSS oblique WCCS unless there are specific finding of facts recorded by competent authorities to indicate the complicity of the transporter in such malpractices. Full stop. There is no such finding of fact available. There is no such material available on record to arrive at a conclusion as regards complicity of the petitioner in diversion and oblique theft oblique replacement of inferior quality of food grains while the same were in transit. Full stop. Under the circumstances, this court is of the unhesitant opinion that the present is not a case where clauses 6 and 10 would have any application in the facts and circumstances of the case. Full stop. Notwithstanding the same, the respondent number 3 has issued the impugned order with the following impugned order, the operative part of which reads as follows, page 67, double full stop. Full stop. If the impugned order is implemented, the same would not only have serious adverse civil consequences upon the petitioner, but he might even be subjected to future penalties. He may even be subjected to future proceedings involving penal provisions. Full stop. Therefore, unless the conclusions are drawn on the basis of cogent materials available on record, and the charge is established in a proceeding held in accordance with law and by a competent forum, such an order having serious adverse civil consequences upon the petitioner cannot be sustained in the eye of law. Full stop. Having regard to the facts and circumstances of the case, this court is therefore of the opinion that there is no cogent basis for the respondent number 3 to issue the impugned order against the writ petitioner. Full stop. In other words, I do not find anything on record to indicate the complicity of the petitioner or contravention of any of the terms of the contract agreement, including the obligation to supply to complete the transportation in the tier 2 level on account of the fact that the learned departmental council has failed to produce any material before this court to indicate that any instruction to carry out supply at the tier 2 level was not efficiently carried out by the writ petitioner. Full stop. Consequently, this writ petition succeeds and is hereby allowed. The impugned order (Annexure 10) is hereby set aside. It is, however, made clear that this order would not come in the way of the authorities to initiate appropriate action against any person guilty of malpractice in accordance with law by taking recourse to procedures established under the rule of law. Stop. With the above observation, writ petition stands allowed. There will be no order as to cost. Yes?
Yes.
Anything else?
No. That your lordship's order will help me now to, if my money was forfeited, that will come back now. No issue.
That's over. Okay, you just come to the chamber. Give me that. Where is